Hello and welcome. My name is Alan, and today we will continue our talk on the Supreme Court, picking up with cases of the Marshall Court. Because the last three videos we went over dealt with members of Marshall Court, including Chief Justice John Marshall and then the other 10 members that went in and out. But let's read something right quick I wanted to mention from my constitutional law book here. It says the contracts clause of Article 1, Section 10 forbids states from passing laws impairing the obligation of contracts. Historically, this clause was extremely important in the protection of economic freedoms and private property. Like many important constitutional provisions, the Contracts Clause was first given life during the era of Chief Justice John Marshall. And key decisions they have listed with Marshall in the Contracts Clause are Fletcher versus Peake, 1810, and the Dartmouth College case. Marshall himself went so far as to assert that the Contracts Clause barred state bankruptcy laws that applied to debts incurred after their passage. But on this occasion, the legislation was upheld by a majority of his brethren, leaving Marshall to record his only dissenting opinion in a constitutional case, Ogden versus Saunders. So I just wanted to mention this since we are discussing the Marshall Court, and so I had to look and see if my constitutional law book held any information on the Marshall Court. But let's get into what I've got online here. There are a huge number of cases that the Marshall Court went through. Because you have to remember, Marshall was the Chief Justice for 34 years and 152 days. So we're talking caseload probably in the hundreds, if not higher. But let's go over some of the major ones here. And then we'll go in further look at three in particular that if you're going to study anything with government, law, anything, you have to know something about these cases. But first, let's get some of the other important ones. We have Talbot versus Seaman, an 1801 case where it involved maritime law, specifically the circumstances under which salvage rights attached to a neutral vessel captured by enemy forces and then captured by the U.S. Navy. And on Wikipedia here it says the summary is salvage right or maritime salvage rights in time of war. So next one we want to look at is Stewart versus Laird, 1803, and it was a case decided by the U.S. Supreme Court, notably a week after one of the more famous cases we're going to talk about in particular, Marbury and versus Madison. So, but Stewart versus Laird says enforceability of rulings issued by judges who have since been removed from office. So, let's say a judge makes a decision, like a ruling on a crime or something, but then is removed from office. Whether he be voted out, impeached, whatever it may be. But yeah, next one we will look at is Little versus Barine, 1804. The court found that the President of the United States does not have inherent authority or inherent powers that allow him to ignore a law passed by the U.S. Congress. The next case we want to look at is Bailiff versus Tipping, which was 1805. And it said that the court held that a citation must accompany a writ of error in order for the court to hear a case. So, yeah. Next one we want to mention is Strawbridge versus Curtis, 1806. And the Supreme Court first addressed in this case the question of complete diversity for diversity jurisdiction. Next case is Ex parte Bowman. It was 1807. And it was a case in which Bowman held that the constitutional definition of treason excluded mere conspiracy to levy war against the United States. So, again, the summary here, habeas corpus and the definition of treason and the Supreme Court's power to issue writs of circuit courts. So, yeah, that's what the case dealt with. And again, I'm getting these just off a list on Wikipedia here, which will be in the description below the video in the sources that I list. So, next case we want to just mention here is Fletcher versus Peck. And it was an 1810 case. Remember, the last one was 1807. So there's a 3-year gap here, which the cases just were nothing of major notice. So, but anyway, 1810, Fletcher versus Peck. It was a Supreme Court decision in which the court first ruled a state law unconstitutional. And the decision also helped create a growing precedent for the sanctity of legal contracts. So, yeah. Remember when I read to you off the my constitutional law book, Fletcher versus Peck was one of those ones they mentioned. But yeah, it dealt with the contracts clause. Next one is the United States versus Hudson and Goodwin, 1812. it deals with federal court jurisdiction over common law crimes, saying that Congress must first enact a constitutional law criminalizing an activity, attach a penalty, and give the federal courts jurisdiction over the offense in order for the court to render. Let's see if we can read this in full here. This is kind of similar to something we mentioned earlier, I get the feeling. In order for the court to render a conviction. So the defendants, Hudson and Goodwin, were charged with a libel on the president and Congress. And they were accused of secretly voting to give Napoleon Bonaparte $2 million to make a treaty with Spain. The circuit court was divided on whether it could exercise common law jurisdiction over such cases. And in the decision, Justice William Johnson Jr. delivers the opinion of the court, saying that the federal government is one of limited powers as set forth in the Constitution. And here's what it says, per Wikipedia, it says, the court held, quotation, the legislative authority of the Union must first make an act a crime, affix a punishment to it, and declare the court that shall have the jurisdiction of the offense, unquote. It also mentioned an exception to the general rule, saying that courts have some implied powers, such as punishing litigants for contumacy or contempt of court. So, yeah. But anyway, the United States versus Hudson and Goodwin. When did I say it was? 1812. But the next one we want to look at is the Schooner Exchange versus McFadden, which was also 1812. And the summary says, capture and possession of foreign ships. It was a case on the jurisdiction of federal courts over a claim against a friendly foreign military vessel visiting an American port. But the next one we want to look at is Fairfax's Device versus Hunter's Lessee, 1813, which deals with loyalist property forfeiture. It arose out of the acquisition of Fairfax land in the northern neck of the state of Virginia by the family and associates of John Marshall. Next one we want to look at is Martin versus Hunter's Lessee, 1816, 3 years later. And it dealt with loyalist property forfeiture again, and the Supreme Court review of state court judgments. And it says here under a synopsis that it was decided on March the 20th, 1816, and was the first case to assert ultimate Supreme Court authority over state courts in civil matters of federal law. So, yeah. Next one we want to take a quick peek at is Laidlaw versus Ogden, 1817. And it was a case decided by the U.S. Supreme Court that established caveat emptor in the U.S. And caveat emptor is Latin for let the buyer beware. Next one we want to look at is Craig versus Radford, 1818. Summary says the Jade Treaty protection of alien enemy defeasible estate and surveying law. Quick synopsis was that it was a decision delivered by Justice Bushrod Washington on March the 12th, 1818, from a dispute that arose from a suit in Chancery to establish a clear title to land in Kentucky located on the south bank of the Ohio River. Next one we want to mention is Sturgis versus Crowninshield, 1819. Summary saying constitutionality of state bankruptcy laws and retroactively applying those laws, specifically in New York. And the next case we want to look at is the Trustees of Dartmouth College versus Woodward, which was to deal with impairment of contracts. U.S. corporate law case from the U.S. Supreme Court dealing with the application of the Contracts Clause of the U.S. Constitution to private corporations. And the next one we want to kind of mention is Cohens versus Virginia, 1821, dealing with the judicial review of the state Supreme Court decisions. And it was a landmark case by the Supreme Court that is most noticeable for the court's assertion of its power to review state Supreme Court decisions in criminal law matters when the defendant claims that their constitutional rights have been violated. So you've got to remember, you've got the U.S. Supreme Court, but each state's also got a Supreme Court. The Virginia Supreme Court, the Wyoming Supreme Court, the Washington Supreme Court, Florida Supreme Court. All these states have their own Supreme Court as the highest point within the state's hierarchy. So, yeah. And the next one we want to look at is Johnson versus Mintosh, 1823, and it deals with the inability of Native Americans to own land. It was a decision in which the Supreme Court held that private citizens could not purchase lands from Native Americans. So I guess they were trying to say that Native Americans couldn't own the land for it to be purchased in the first place. Next one we want to mention is Osborne versus the U.S., or versus the Bank of the U.S., 1824. And it deals with the scope of Article 3 jurisdiction and an interpretation of the 11th Amendment. The next one we want to look at is the Antelope, 1825, which is the Supreme Court's initial consideration of the legitimacy of the international slave trade. So remember, slavery at this point is still going on, still legal. But it was the first time that the U.S. Supreme Court considered the legitimacy of the international slave trade and determined that the possession on board of a vessel was evidence of property. Next one we want to look at is Ogden versus Saunders, 1827, which deals with state bankruptcy laws. It determined the scope of a bankruptcy law in contrast to a clause of the Constitution of the U.S. And it was the only constitutional decision from which Chief Justice John Marshall dissented during his entire period as Supreme Court Chief Justice. So he dissented from the court's majority opinion. My foot's trying to go numb on me. That's why the camera's moving around. Sorry about that. Next one we want to kind of just mention is the American Insurance Company versus 356 bales of cotton from 1828. And the summary says the territorial clause and the ability of Congress to set up Article 1 tribunals. The case involved the validity of the local court established by Congress in the Florida Territory, whose judges lacked life tenure to deal with a specific case. Okay. Next one we want to kind of mention here is Wilson versus Blackbird Creek Marsh Company from 1829. It deals with the Dormant Commerce Clause. Specifically, the definition of the Commerce Clause in Article 1, Section 8. I guess it's supposed to be Paragraph 3 of the U.S. Constitution. Let's see if we can look that up and see what that says, because I do have a copy of the Constitution here with me. Article 1, Section 8. And Part 3. It says, to regulate commerce with foreign nations and among the several states, and with the Indian tribes. In which this case it's talking about what Congress can and cannot do. So yeah. Next one we want to kind of mention is the Cherokee Nation versus Georgia, 1831, which deals with Indian nations as foreign states. The Cherokee Nation sought a federal injunction against laws passed by the U.S. state of Georgia, depriving them of rights within its boundaries. But the U.S. Supreme Court did not hear the case on its merits. This is what it says here. Let me open this up a little further and take a little more in-depth look here. It ruled that it had no original jurisdiction in the matter, as the Cherokees were a dependent nation with a relationship to the United States like that of a ward to its guardian. 1 year later, in Worcester versus Georgia, the U.S. Supreme Court ruled that the Cherokee Nation was a sovereign. So in Cherokee Nation versus Georgia, the Supreme Court saw that the Cherokee Nation was not independent. But just 1 year later, in a different case, they cited that they were indeed sovereign. According to the decision rendered by Chief Justice John Marshall, it meant that Georgia had no rights to enforce state laws in its territory upon the Cherokee. Although President Andrew Jackson decided not to uphold the ruling of this case and directed the expulsion of the Cherokee Nation, which we now know as the Trail of Tears. So they were led from their own land to Oklahoma. But yeah, Cherokee Nation versus Georgia, 1831. And then 1832 was that Worcester versus Georgia, dealing with Indian removal. Which we did talk about. The U.S. Supreme Court vacated the conviction of Samuel Worcester and held that the Georgia criminal statute that prohibited non-Native Americans from being present on their Native American lands without a license was not valid, because, as we said, they then ruled that the Cherokee Nation was in a sovereign nation. Next one we want to kind of mention is Barron versus Biltmore, 1833, which dealt with the reach of the Bill of Rights. This case helped define the concept of federalism in the U.S. constitutional law, and the court ruled that the Bill of Rights did not apply to the state governments, establishing a precedent until the ratification of the 14th Amendment. Next one we want to mention is Ex Parte Moderazo, from 1833, which deals with standing in an admiralty case. It involved the suit of Juan Moderazo, a citizen of the Kingdom of Spain, against the U.S. state of Georgia. So yeah. And the last one we want to kind of just mention here is Wheaton versus Peters, 1834, which dealt with copyright perpetuity and common law copyright. Courts upheld the power of Congress to make a grant of copyright protection subject to conditions and rejected the doctrine of a common law copyright in published works. But yeah, those are the ones we just want to kind of mention before we really get into three big cases we want to deal with here. These three cases are cases you'll want to know, as I was saying before, if you study any kind of government, law, anything like that. These are Marbury versus Madison from 1803, McCulloch versus Maryland, 1819, and Gibbs versus Ogden, 1824. So let's take a look at each of these cases a little more in depth. I just gotta wait for some of this stuff to close up here. The case Marbury versus Madison. Some things to mention from Britannica.com here. February the 24th, 1803. And it was a case that established the doctrine of judicial review. In the weeks before Thomas Jefferson's inauguration as president in March 1801, lame duck Federalist Congress created 16 new circuit judgeships in the Judiciary Act of 1801, and an unspecified number of new judgeships in the Organic Act, which President John Adams, proceeded to fill with Federalists in an effort to preserve his party's control of the judiciary and to frustrate the legislative agenda of Jefferson and his Democratic Republican Party. One of the last appointments, William Marbury, was a Federalist Party leader from Maryland and did not receive his commission before Jefferson became president. And once in office, Jefferson directed his Secretary of State, James Madison, to withhold the commission of Marbury. But Marbury petitioned the Supreme Court to issue a writ of mandamus to compel Madison to act. So Marbury and his lawyer argued that the signing and sealing of the commission completed the transaction, and that the delivery, in whatever event, constituted a mere formality. So it was the actual signing and sealing the commission to go out, is what they're claiming, guaranteed that Marbury should have been assigned as a judge. The court did hear the case, Now, some scholars do question whether Marshall should have removed himself from the case because he was John Adams' Secretary of State and thus was responsible for delivering a lot of these commissions. And again, Britannica here is saying certainly later judicial standards would have called for recusal, but at the time only financial connections to a case led judges to step aside. And as per Britannica, the decision is that the Chief Justice recognized the dilemma that the case posed to the court. And if the court issued the writ of mandamus, Jefferson could simply ignore it because the court had no power to enforce it. If, on the other hand, the court refused to issue the writ, it would appear that the judicial branch of the government had backed down before the executive branch, and that John Marshall would not allow. What he chose to do has properly been termed as a real tour de force. Marshall managed to establish the power of the court as the ultimate arbiter of the Constitution, and chastised the Jefferson administration for its failure to obey the law and to avoid having the court's authority challenged by Jefferson's administration. So yeah, this law really set groundwork for the Supreme Court to really decide that, yes, it was the one that would decide if a law was fair and legal and everything else. And it also probably helped enforce this idea that we have a separation of powers with the judicial branch, the legislative branch, and the executive branch. The executive being the president and his cabinet members, and the other positions within that executive branch. So, yeah, we have that. Legislative is your Congress, the House of Representatives, and the Senate. And the judicial is the Supreme Court and the undercourts. And the idea is that the Supreme Court helps to examine the laws and say these are fair or these are constitutional. Of course, it can also go and say, no, these are not constitutional. These are not fair. And that's a lot of where that power of judicial review actually comes from. Okay, per Wikipedia, a quick synopsis it's got here is judicial review is a process under which executive or legislative actions are subject to review by the judiciary. A court with authority for judicial review may invalidate those laws, acts, or governmental actions that are incompatible with a higher authority. So, the president issues executive actions or executive orders, they still have to meet within the Constitution's guidelines. And the Supreme Court can look at those and go, that doesn't meet within the boundaries of the Supreme Court. And the same with the laws written and passed by Congress. If there's a question about it, the Supreme Court can go, yeah, that violates what is set forth here in the Constitution. But yeah, Marbury versus Madison. A very, very huge case. And if you ever want to know anything about American government, American history, American law, this is one of the cases you must know. Marbury versus Madison. Or at least, are aware of. The next case we're going to talk about is one of the big three. This is McCulloch versus Maryland, which deals with the doctrine of implied powers. 1819. So let's take a look at it here. Let's open up Britannica. All right. In the case McCulloch versus Maryland, Britannica.com cites that John Marshall affirmed the constitutional doctrine of Congress, or of Congress's implied powers. And it determined that Congress had not only the powers expressly conferred upon it by the Constitution, but also had all authority appropriate to carry out such powers. So your idea is that the Constitution writes out specific things that Congress can and must do. But if there is something that they feel would help achieve those ends, those are implied powers that were brought about in McCulloch versus Maryland. In the specific case, this is from Britannica.com again. In the specific case, the court held that Congress had the power to incorporate a national bank, despite the Constitution saying nothing on both the creation of corporations and the chartering of banks. The court decided that since a national bank would facilitate the accomplishment of purposes expressly confided to the federal government, such as the collection of taxes and the maintenance of armed forces, Congress had a choice of means to achieve these proper ends. Implied powers, McCulloch versus Maryland. Let's see. Let's go to the Wikipedia page on it here. Okay, the state of Maryland had attempted to impede an operation by the Second Bank of the United States through a tax on all notes of banks not chartered in Maryland. So because this was a federal bank and not a state bank, Maryland says, hey, we have the power to tax it because it's not officially chartered here in Maryland. The court invoked the necessary and proper clause of the Constitution. That's a clause you'll hear a lot of, necessary and proper. But It allowed the federal government to pass laws not expressly provided for the Constitution's list of express powers if the laws are useful to further the express powers of Congress under the Constitution. Let's see if Wikipedia mentions anything else here. It also helped establish a bit of power of the federal government over state power. Because one thing you have to remember, before the Constitution was the Articles of Confederation, which was the law of the U.S. But after the Revolutionary War, and while the U.S. was under the Articles of Confederation, these state powers have so much more power than the federal government. And it was making it difficult because you had no standard form of currency between states for interstate trade or for federal payment. Because one of the big issues was you have all these veterans from all these different states, but not all states use the same form of currency. Massachusetts currency would be different from Georgia. New Jersey's currency would be different from Maryland. So yeah, to pay these soldiers was proving difficult. Which was one of the reasons the Constitution came into being. But this helped establish further that the federal government had power over the state government. And let's look at our last case that we really want to delve into. Gibbs versus Ogden, 1824. And the summary cites congressional power to regulate interstate commerce. So let's look at it on Britannica.com. And it says the U.S. Supreme Court case established the principle that states cannot, by legislative enactment, interfere with the power of Congress to regulate commerce. The state of New York agreed in 1798 to grant Robert Fulton and his backer, Robert R. Livingston, a monopoly on a steamboat navigation in state waters if they developed a steamboat capable of traveling 4 miles per hour upstream on the Hudson River. Fulton and Livingston satisfied the actual condition of the grant, and subsequently Aaron Ogden purchased from Fulton and Livingston rights to operate steamboats between New York City and New Jersey. In 1819, Ogden sued Thomas Gibbs, who was operating steamboats in the same waters without the authority of Fulton and Livingston. And in 1820, Ogden won in the New York State Court of Chancery. The case was appealed to the Supreme Court by Gibbs, saying that he was protected by terms of a federal license to engage in coasting trade. The Supreme Court ruled in favor of Gibbs. And it helped develop an interpretation of the Commerce Clause of the Constitution. But that's from Botanica.com. Let's look at Wikipedia here. Per Wikipedia, it gives a quote here. If, as has always been understood, the sovereignty of Congress, through limited to specified objects, or though limited to specified objects, is planetary as to those objects, the power over commerce with foreign nations and among the several states is vested in Congress as absolutely as it would be in a single government, having in its constitution the same restrictions on the exercise of power as are found in the Constitution of the United States. But yeah, that was Gibbs versus Ogden, allowing the U.S. to regulate interstate commerce. Because again, remember during the Articles of Confederation, the states held most of the power. So interstate commerce was more or less between the states. And they decided how things went. So it was more like, you agree to this? Cool, I'll agree to it. We're good. But the U.S. federal government, as per the Constitution, and was cited in Gibbs versus Ogden, allowed the U.S. to say, this is what happens in interstate commerce. This is what rights these people have. And it also allowed the U.S. Constitution the encompassing power to regulate navigation. So, but yeah, Marbury versus Madison, McCulloch versus Maryland, and Gibbons versus Ogden. Remember those cases. But that'll be it for now. As always, educate thyself, think, read, study, learn. Someone tries to tell you something you have trouble believing, ask them to cite their sources. Speaking of, I will be listing the sources in the description below the video. But I'll see you all in the next one. Until then, later.